The UNFCCC Standing Committee on Finance estimates that developing countries, including SIDS, require up to $584 billion annually by 2030 to address their costed needs and respond to the climate crisis. Yet, the recent COP29 decision pledged only $300 billion per year, leaving a staggering gap that delays adaptation, deepens vulnerabilities, and worsens losses. This underscores the urgent need for clarity on states' obligation under international law to protect vulnerable nations. Mr. President, Mr. Wordsworth, and thereafter Ms. Sanders, members of Belize Council team, will address you today, developing Belize's legal arguments. Mr. President, honorable members of this special chamber, that concludes Belize's opening statement. I now ask that you give the floor to Mr. Wordsworth.
I thank Mr. Williams. I now give the floor to Mr. Sam Wordsworth. Sir, you have the floor.
Mr. President, members of the Court, it is a privilege to appear before you for Belize, and I wish to start my brief remarks by recalling the deep importance of the current task before the Court, but also by asking whether there is such great legal complexity to one of the central issues before you, that is the application of the customary international law obligation of prevention in the current context. The Court now has before it no fewer than 6 lines of argument that seek to neutralise the existence or impact of the prevention obligation in the context of climate change, a display of legal firepower from those states most engaged in carbon consumption or production that makes one raise a quizzical eyebrow as to the hope that there will ever be agreement within the COP to meaningful and binding treaty obligations to reduce emissions. The first argument on neutralisation is that greenhouse gas emissions are somehow the wrong sort of harm and thus fall outside the prevention obligation. This is despite the fact that the harm occurs outside the emitting state's borders, constitutes existential harm to neighbouring and other states, and so is by definition significant transboundary harm. And of course, if this were not a relevant and applicable norm in this context, it would not be expressly referenced in the preamble to the UNFCCC. The argument is not serious, and it is irrelevant that the Court thus far happens only to have applied the prevention obligation with respect to environmental harm suffered by a neighbouring state. A second and related argument is that the specific content of the prevention obligation has not been established by state practice and opinio juris in the current context of climate change. But the relevant content is established. It is the due diligence obligation of prevention, which is universally recognised, and likewise that this must be applied in the given fact-specific context here of climate change and greenhouse gas emissions. The third argument, aimed at neutralisation, invokes lex specialis. It is as if the Court had not many times confirmed that the same factual situation can readily give rise to the application of 2 or more sets of legal norms, and this is all the more unproblematic where, to quote the ILC on this topic, there is no actual inconsistency between them or else a discernible intention that one provision is to exclude the other. Or plainly, there is no inconsistency. And where is the evidence of a discernible intention to exclude the prevention obligation? Nowhere in the UNFCCC and nowhere in the Paris Agreement can one see that. And please recall the multiple declarations from states expressly clarifying that there had been no derogation. The fourth attempt at neutralisation seeks to invoke Article 31.3c of the Vienna Convention with respect to the interpretation of climate change treaties. But I needn't dwell on this because the customary rule of prevention anyway applies in parallel. But the requirement that an applicable rule of international law shall be taken into account does not, in any event, mean that the rule is to be treated as displaced or neutralised by the treaty provision at issue. The fifth argument on neutralisation, which one also saw deployed yesterday, is that compliance with obligations under the Climate Change Treaty will automatically mean compliance with the obligation of due diligence under the prevention obligation. But this makes no sense. What is required for due diligence depends on what an individual state has itself done in the specific situation to meet the specific obligations it owes under the prevention obligation. And the court has stated in clear terms, and as can only be correct, that the notion of due diligence calls for an assessment in concreto. The final argument on neutralisation is that the UNFCCC and Paris Agreement establish a self-contained regime, displacing the usual rules on state responsibility. Where again, one might ask, can one locate any agreement to that effect? Again, there is none. And the argument is based on assertion and assumed difficulties of application alone. Mr. President, members of the court, if I can conclude with an analogy that seems apt. It is said that in order to catch a macaque monkey in the Philippines, all that is needed is a large glass jar with a narrow neck and a small mango. Having reached in, the macaque is hardwired to hold on to a prized morsel of food, and so cannot remove its fist from the jar, clenched as it is around the mango. Although free to escape, it will not let go, and hence awaits an unpleasant fate. The analogy is, of course, entirely clear. In human terms, it currently appears impossible voluntarily to let go of the lifestyles now enjoyed, in particular in the global north, and likewise for states to let go of carbon-based revenue streams. But in terms of international law, we are in the realm of obligation, not discretion. Who knows when or if the competing interests of states will ever lead to meaningful treaty-based obligations of reduction within the COP. But hard-edged obligations already apply as a matter of the prevention obligation in customary international law. Mr. President, I ask you now to call on Ms. Sander, who will develop Belize's submissions on the prevention obligation and the issue of causation. I thank you.
I thank Mr. Wordsworth. I now give the floor to Ms. Amy Sander.
Mr. President, members of the court, it's an honour to appear before you. There is a river. The river flows through various states. States A, B, C, and D. States A and B have, to varying but significant degrees, each dumped quantities of a metal pollutant in the river. For states C and D downstream, because of the cumulative presence of the metal pollutant, their harvests are decimated and biodiversity destroyed. Now, it could not seriously be contended that states A and B are not each subject to the well-established customary international law obligation to ensure that activities within their jurisdiction or control do not cause significant harm to the environment of other states, what Belize has termed the prevention obligation. And that obligation applies with respect to harm to states C and D, as well as to any other states in the same position. It makes no difference how many states may suffer the significant harm. Yet, replace the metal pollutant with greenhouse gases and the river with atmosphere, and that is in essence what some states in these proceedings have contended. It has been said in categorical terms that because the harm caused by greenhouse gas emissions results from cumulative emissions and various sources and impacts not just one neighbouring state, that the prevention obligation is simply inapplicable in this context. That inapplicability contention is advanced despite the fact that the court has never formulated the obligation in such restrictive terms, and despite the express reference to the obligation in the UNFCCC's preamble, reflecting a clear acknowledgement that it does apply in the present context. And this inapplicability contention is advanced despite the fact that we know the best available science is unequivocal that all greenhouse gas emissions above a de minimis level contribute to the risk of serious harm through climate change. Furthermore, if that inapplicability contention were accepted, it would follow that a critical aspect of the prevention obligation, namely the obligation to carry out an assessment of potentially harmful activities, what Belize has termed the assessment obligation, would not apply to states' emissions. But it would be perverse if a state were obliged under customary international law to assess the environmental impact of a factory in its territory, emitting a metal pollutant into a river that risks causing significant harm to one or more states, yet not as regards the factory next door pumping greenhouse gases into the atmosphere, contributing to catastrophic harm to all states. The separate treaty obligation under Article 4 of the UNFCCC, a passing reference to impact assessments framed in broad terms as a possible appropriate method, and of course applicable only to state parties to the treaty, does nothing to displace the independent customary obligation. Belize does recognise that some element of causation is wrapped up in the content of the prevention obligation itself. The obligation requires a state to exercise due diligence to prevent harm being caused to the environment of other states. So these proceedings present the court with an opportunity to explain how causation operates with respect to the applicability of the prevention obligation. This is, of course, a distinct issue from the subsequent question of how causation may be treated when considering reparation for a breach of the obligation. Belize first sets out 4 foundational points which it considers to be uncontroversial, before turning to make 3 submissions on causation with respect to the applicability of the prevention obligation. First foundational point: there is no single legal test under international law for determining whether a sufficient causal connection has been established in a given case. Depending on the context, various tests of causation have been applied by international and domestic courts. Some are more demanding than others, driven at least in part by the recognition that the just solution to different kinds of cases may require different causal tests. Second foundational point: the applicable causal test must be informed by the precise content of the relevant international law obligation. Third, and as indicated earlier, the science is clear. Greenhouse gas emissions of State A contribute to the total greenhouse gas concentrations in the atmosphere, and the total greenhouse gas concentrations will cause climate change harms. So there's an indisputable chain of causation between State A's greenhouse gas emissions and the relevant harm. Belize referred to this in its written submissions as general causation, to be contrasted with specific causation, which refers to a specific act or policy causing a specific harm. Fourth foundational point. The fact that a given harm has multiple causes does not mean that a state's obligation to take measures to avert that harm is somehow disapplied or even attenuated. You already have my example of the river and the metal pollutant. Another helpful example is drawn from the court's judgment in Bosnia genocide. The court held that the fact that a state's compliance with its preventive obligation could not have averted the relevant result would be, and I quote, irrelevant to the breach of the obligation of conduct in question, the more so since the possibility remains that the combined efforts of several states, each complying with its obligation to prevent, might have achieved the result, which the efforts of only one state were insufficient to produce. Building on those four foundational points, Belize makes three submissions. First, for the purpose of the applicability of the prevention obligation, general causation suffices to meet what the European Court of Human Rights has termed the legally relevant relationship of causation. And this approach is consistent with ITLOS's position regarding the applicability of the UNCLOS obligation to prevent pollution of the marine environment in the context of climate change. The relevance of general causation here is evident from the precise content of the prevention obligation, and I recall here my second foundational point. Specifically, international courts have consistently spoken of the need to ascertain whether there is a risk of significant transboundary harm. So for the obligation to arise, it's not necessary that the state could foresee the precise form of possible harm or the precise victim states. Indeed, the prevention obligation encompasses the assessment obligation, and it's only through conducting an assessment in the first place that any such specific risks could be reliably identified. It's thus sufficient that states can foresee harm to the climate system as a whole, to all states, as a result of greenhouse gas emissions above a de minimis level. Thus, applying a threshold of general causation here is not, as has been suggested in these proceedings, an argument that rests on the court generating any novel principle of international law. It's an orthodox application of the well-established elements of the existing customary rule. Second submission, in assessing the risk of harm resulting from a particular activity or policy by reference to general causation, the cumulative impacts of other activities, whether of the relevant state or a third state, must be taken into account. Returning to my river example, before State A permits the release of the metal pollutant into the river from a factory on its territory, that state would clearly be obliged to consider the already accumulated levels of the metal pollutant in the river, as well as any reasonably foreseeable future levels of the metal pollutant to be emitted by State A or any other state. And intuitively, the same applies to greenhouse gases. And this approach is reflected in the decisions of ITLOS and the Inter-American Court of Human Rights. Third submission, as to the separate question of specific causation, that is, whether a specific act of State A in fact caused a specific identifiable harm in a given other state, that specific causation is relevant at a subsequent stage of the invocation of responsibility when reparations are being sought and determined. That was a point squarely made by ITLOS in the context of Article 194 of UNCLOS. Now, that subsequent stage would clearly be a fact-specific assessment, and several states agree that a threshold of but-for causation would be inappropriate. One could pose hypothetical cases involving large-scale emissions where a sufficiently quantifiable harm emanating from a specific project or a specific state could in fact be evidenced by best available science. And we have seen domestic courts engaged in aspects of such quantification. But the key point for present purposes is this. Any difficulty in establishing specific causation in certain claims for reparation is not a principal basis to foreclose the applicability of the prevention obligation in this context altogether. In these proceedings, pragmatic guidance from the court is key, and with that in mind, I focus now on one hard-edged, concrete aspect of the prevention obligation, the assessment obligation. ITLOS described this as a crucial application of the prevention obligation, vital for identifying risks of harm before they materialise, as well as ensuring public awareness of the impact of activities and public participation on what is or isn't done to our planet. To cite the Apex Court of the United Kingdom earlier this year, you only care about what you know about. With reference to the well-established jurisprudence of this court, Belize identified 3 stages to the assessment obligation as follows. Stage 1, identifying an activity having the potential adversely to affect the environment of another state. Stage 2, ascertaining whether the activity poses a risk of significant transboundary harm. Stage 3, where such risk exists, conducting the assessment itself. And the application of each stage to greenhouse gas emissions is addressed in detail in Belize's written submissions. Today, I highlight the following points. First, it is well established that the assessment obligation applies to specific activities planned to occur within a state's territory or otherwise within the state's jurisdictional control. Applied to greenhouse gas emissions, it includes activities planned by a developer or contractor, including private actors, as well as a state's broader policy decisions to allow relevant emitting activities. Second, as to the threshold of a risk of significant transboundary harm, this denotes an objective assessment referring to a possibility rather than a likelihood. The due diligence standard takes into account both the degree of the risk of harm and the gravity of the consequences if the risk materialises. With respect to greenhouse gas emissions of particular relevance, of particular significance are A, the best available science as reflected in the IPCC reports, and B, the precautionary principle. And there must be taken into account both sensitive receiving environments, such as Belize's coral reefs, as well as indicated earlier, cumulative impacts. My third point, the information contained in the assessment must be sufficient to allow informed decision-making in the state of origin and to meet the needs of potentially affected states in understanding the degree and seriousness of the risk of adverse transboundary impact. Whilst not authoritative, Appendix 2 of the Espoo Convention offers useful general guidance in that regard. Fourth, the states must notify in good faith potentially affected states, where that's necessary to determine the appropriate measures to prevent or mitigate the risk, as was expressly confirmed in the certain activities case. The existence of this obligation flows from both the nature of the requirement to exercise due diligence and the duty to cooperate. Finally, the obligation to undertake the assessment is a continuous one, with monitoring of the relevant activity conducted in accordance with the best available science, so as to evaluate the actual, as opposed to predicted effects of the relevant activity. Flowing from the nature of the requirement to exercise due diligence, the duty to cooperate, and the critical role of enhanced transparency and public scrutiny in the prevention of environmental harm, the monitoring reports must be made public. In conclusion, an opinion affirming the applicability of the prevention obligation to the present context, including an elucidation of the causation analysis and guiding states by identifying the hard-edged contours of the assessment aspect of that obligation would be a concrete outcome of real pragmatic significance. Mr. President, members of the Court, that concludes Belize's submissions.
I thank the representative of Belize for their presentation. I now invite the delegation of Bolivia to address the Court, and I call His Excellency Roberto Calzadilla Sarmiento to the podium.
Mr. President, members of the Court, it is a great honor to appear again before you and to do so on behalf of the plurinational state of Bolivia. Mr. President, climate change stands at the defining challenge of our time and the gravest threat facing humankind, including future generations. With global temperatures already approaching the critical 1.5% threshold, we confront an unprecedented crisis that will shape the fate of generations to come. Its worst consequences are borne disproportionately by those who have contributed less to its course, making this not merely a matter of scientific fact, but fundamentally an issue of justice. Bolivia recognized that the structural causes of climate change stem from the current anthropocentric model, particularly the capitalistic system of development that has dominated the last 2 centuries. The system has precipitated the present climate crisis, violating basic human rights, disrupting Mother Earth's life cycles, leading to ecosystem collapse, upending traditional ways of life for hundreds of millions of people worldwide, and intensifying global hunger and poverty. The question of state responsibility for climate change cannot be divorced from this reality. Not all states bear equal responsibility for anthropogenic climate change, yet developing states, particularly as Bolivia, a landlocked developed country, bear a disproportionate burden of its consequences. This inequity fundamentally undermines the human rights of present and future generations. Mr. President, Bolivia fully maintains all positions articulated in its written statement, to which is respectfully refer you today. We will endeavour to assist the Court today on 5 central issues. First, we will demonstrate that this Court possesses not only the jurisdiction, but indeed the duty to render an advisory opinion on these questions, which are manifestly legal in nature and of paramount importance to the international community. Second, we will examine the relationship between climate treaty obligations and other obligations under international law, establishing why compliance with climate treaties alone cannot absolve states of their broader international obligations. Third, we will address the principles of common but differentiated responsibilities and respective capabilities, demonstrating its status as a fundamental principle of general application in international law, and that must inform the interpretation of all climate-related obligations. And finally, we will examine the duty to cooperate and its specific implications for climate finance, showing how meaningful cooperation through climate finance constitutes not a discretionary act, but a necessary implementation of established legal duties. Mr. President, members of the Court, given the broad consensus among participating states regarding the Court's jurisdictions in this matter, we see no need to belabor this point. The questions before the Court are manifestly legal in character, and the General Assembly's competence to request this opinion is clear. However, we would note that recent developments at the COP29 in Baku demonstrate precisely why the Court's guidance on this question is so vital. The ongoing struggles to secure financial commitments for climate action and the bitter division between states of responsibilities and obligations illustrate how the international community urgently needs clear legal guidance on questions of obligation and responsibility. In these circumstances, Mr. President, we submit not that not only does the court have jurisdiction, but the exercise of its jurisdiction is particularly appropriate and necessary at this moment. Mr. President, I turn to the fundamental question of the scope of states' obligations in respect of climate change. The first question posed to the court requests it to identify the obligations of states in respect to climate change. Bolivia notes that the UN Framework for Convention on Climate Change regime has the fundamental and primary role in addressing climate change issues for the wide range of sources from which climate-related obligations stem. These obligations arise not only from the climate change treaties, but also from customary international law, human rights law, and other international instruments. It must be recorded that some of the participants appear to object to the breadth of the request, arguing that the climate treaties alone apply to the phenomenon of climate change. Others have argued that the climate treaties constitute lex specialis, with the intended implication being that compliance with these treaties should be considered in all cases sufficient, irrespective of the existence of other obligations. These views are untenable for three questions. First, the UNCCF and the Paris Agreement themselves acknowledge the relevance of the other obligations, indicating they were designed to complement, not replace, existing international law obligations. Second, the principle of systemic integration requires that treaties be interpreted in harmony with other applicable rules of international law. This means that obligations under the climate change regime must be read consistently with fundamental principles such as the principle of prevention and the protection of human rights. Third, even if the climate treaties were to be considered lex specialis, which we submit they are not, any displacement of obligations sourced elsewhere would occur as a result of a conflict. No such conflict occurs here. As a result, it cannot be said that compliance with climate treaties may absolve states from their other international obligations. The recent advisory opinion of the International Tribunal of International Law of the Sea confirms this understanding, insofar as it is rejected the notion that compliance with the Paris Agreement alone may satisfy states' obligations under UNCLOS. Different legal regimes create distinct but complementary obligations regarding climate change. Mr. President, this conclusion carries several important implications, of which Bolivia wishes to highlight three. First, different legal obligations may impose varying standards of conduct which should be interpreted in conjunction to address climate change. With the UN Framework Convention on Climate Change regime playing a primary and fundamental role. Second, the historical responsibility for climate change remains relevant under general international law. Third, cross-cutting principles of such as the common but differentiating responsibilities must be understood to operate across these different legal frameworks. In conclusion of this point, Mr. President, Bolivia submits that the court must consider the full spectrum of international legal obligation bearing on climate change, recognizing that compliance with one set of obligations does not excuse the compliance with others. In the Nuclear Weapons Advisory Opinion, the Court affirmed that this principle is part of the corpus of international law relating to the environment, and recently in UNCLOS has confirmed that it applies to climate change. In its recent advisory opinion, the Tribunal has confirmed that in the context of UNCLOS, Article 194, paragraph 2, imposes upon states parties a particular obligation to take all measures necessary to ensure that anthropogenic greenhouse gas emissions under their jurisdiction or control do not cause damage to other states and their environment. The Tribunal emphasized that this amounts to an obligation of due diligence. The key question is whether this established principle of international environmental law applies to greenhouse gases emissions and more broadly climate change. While most participants agree that it does, some argue that it does not on the basis of three main objections. None withstand scrutiny. First, some argue that the global nature of climate change precludes the application of prevention principle as traditional applied to bilateral transboundary harm, that this argument fundamentally misunderstands the nature of the obligation. The principle necessarily encompasses all forms of significant harm, regardless of the precise pathways through which that harm occurs. Moreover, the global character of climate harm strengthens rather than weakens the application of the prevention principle. If states must prevent localized transboundary harm, the harm which threatens the rights of one state, they must fortiori prevent contributions to global environmental damage that threatens the fundamental rights of all states. Second, it is suggested that the cumulative nature of emission negates individual state obligations, inter alia because the resolution of climate crisis requires collective efforts and cooperation. These two must be rejected. The principle of prevention has always encompassed forms of harm resulting from aggregate conduct. Moreover, the objection is strictly speaking a classification error. Obligations do not become collective by virtue of their breach contributing to cumulative harm. Thus, it cannot be said that the nature of the harm absolves individual states of their obligations. Understanding those obligations within the framework of historical responsibilities and the principles of equity and common but differentiated responsibilities. Third, this understanding is reinforced rather than undermined by the fact that substantive obligations are accompanied by procedural obligations, because it is only through cooperation that states can effectively manage and prevent environmental risk. Procedural obligations such as those of cooperation, notification and consultation are vital for protecting shared resources that can only be safeguarded through continuous cooperation. But the Court has emphasized that prevention requires cooperation precisely because environmental challenges cannot be addressed in isolation, but because shared challenges absolve individual states of their primary obligations. Fourth, some states point the difficulties of causation and attribution. The complexity of climate science cannot be used to evade obligations under international law, and in any event, matters of causation and attribution must be examined in relation to the relevant rules concerning the consequence of the breach of primary obligations, which Bolivia submit are to be found in the law of state responsibility. On the contrary, causation and attributions play no role in determining the existence and scope of primary obligations. Mr. President, I turn now to the principle of common but differentiated responsibilities and respective capabilities. The question of the legal status of the CBDR principle has generated significant debate. Some states contend that this principle operates exclusively with the framework of environmental treaties, particularly the climate change regime. Others maintain that it may instead inform obligations across different legal regimes. Bolivia aligns itself with this later view. Two key considerations supporting recognizing the common but differentiated responsibilities and respective capabilities as a principle of general application in international law. First, these principles may be seen as a specification of the principle of equity. It operationalizes the recognition that states which have contributed differently to the climate crisis and which have different capacities to address them cannot be held to identical standards. Second, there is growing recognition that this principle is applicable to the question of climate change beyond the scope of environmental treaties. For example, the International Treaty on Law of the Sea recently confirmed that while the UN Convention of Law of the Sea does not explicitly refer the principle of common but differentiated responsibility, it contains elements common to this principle. Similarly, the principle has been found to shape the understanding of human rights obligation in the context of environmental protection. The implication of recognizing these principles' broader status are significant. It means that the principle must inform the interpretation of all obligations relevant to climate change, not just those under the climate treaties. In this connection, Bolivia wished to draw attention to two specific points. First, CBDR-RC affects the assessment of due diligence standards across different legal systems. What constitutes appropriate measures to prevent environmental harm necessarily varies according to both states' historical contributions and present capabilities. The standard expected of states must reflect both the differential contribution to environmental harm and their varying capacities to address it. In its advisory opinion, the ITLOS confirmed that the scopes of measure to reduce anthropogenic greenhouse gas emissions may differ between developed states and developing countries. And while all states must make mitigation efforts, developed states should continue taking the lead. This differentiation is particularly relevant for landlocked developing countries such as Bolivia, whose historical contribution to climate crisis has been insignificant. Second, may be relevant not just for the assessment of the obligation of state in respect of climate change, but also for the consequence of the breach. Mr. President, on this point, some states emphasize that this principle necessarily influences how state responsibility operates in the climate context. They argue that responsibility cannot be assessed without reference to states' historical contributions to the problem. Some participants point to the paradox of applying identical standards of responsibility to states that have contributed vastly different amounts to cumulative emissions. Other states strongly contest and link between these principles and state responsibility. They argue that the common but differentiated responsibility is forward-looking and cooperative in nature, designed to facilitate future action rather than assign responsibility for past conduct. These states maintain that the principle cannot modify the established rules of state responsibility, which they argue operate independently of states' different circumstances or capabilities. Bolivia submits that the truth lies between these extremes. The principles neither displace nor overrides the law of state responsibility. The basic elements required to establish responsibility, breach of an obligation, attribution and causation, absence of circumstances precluding wrongfulness remain unchanged. However, CBDR-RC necessarily informs how these elements are assessed in the climate context, including on the basis of the historical contribution to the harm. This is particularly relevant in three ways. First, in determining whether a breach has occurred, the content of the primary obligation itself should be assessed on the basis of the principle of common but differentiated responsibilities. Second, in assessing causation, the historical dimension of greenhouse gas emission cannot be ignored, as it forms part of the factual matrix against which responsibility must be determined. Third, in considering appropriate reparation, the principle of full reparation must be understood in light of states' different capabilities and circumstances. This understanding better reflects both the reality of climate change and the fundamental nature of this principle of common but differentiated responsibilities as a specification of the general principle of equity. It allows for responsibility to be determined in a manner that accounts for historical contributions while preserving the essential features of the law of state responsibility. Third, these principles inform the duty of cooperation, to which I now turn, Mr. President. When states cooperate to address global challenges, they must do in a manner that accounts for different levels of responsibility and capability. This requires operate independently of specific treaty provisions. The duty to cooperate stands as a fundamental pillar of international environmental law, particularly in addressing the climate crisis. This obligation derives from multiple sources of international law and has been consistently recognized by international courts and tribunals, given that impacts on the climate system results from cumulative actions over an extended period. Not a single state can halt it, nor address its consequences in isolation. This duty finds its expression in Article 1 of the UN Charter, which commits states to achieve international cooperation in solving international problems of economic, social, cultural, or humanitarian character. The Charter obligation is further reinforced by Article 56, under which member states pledge themselves to take joint and separate action in cooperation with the organization to achieve the purpose set out in Article 55. In the environmental context, the duty to cooperate is reflected in foundational instruments, including the Principle 24 of the Stockholm Declaration, the Principle 7 of the Rio Declaration. Most recently, ICLOS characterized cooperation as a fundamental principle in the prevention of pollution of the maritime environment. The Climate Change Treaty regime provides specific expression to these cooperative duties without displacing broader obligations under general international law. The UN Framework on Climate Change preambles explicitly acknowledge that the global nature of climate change calls for the widest possible cooperation by all countries. The Paris Agreement elaborates concrete mechanisms through Article 7 on adaptation, Article 8 on loss and damage, Article 9 on finance, Article 10 on technology, and Article 11 on capacity building. The duty to cooperate, which emerged as a specification of the principle of good faith, is not merely a general obligation under customary international law, but requires specific content to be effective. This duty extends beyond formulating and elaborating commitments in multilateral framework agreements. And it is a continuing, nature cannot be satisfied by one-time act. The duty to cooperate is neither an aspirational policy preference nor an inchoate obligation lacking any meaningful content. In the climate context, this cooperation must primarily flow from developed to developing states and constitute an obligation for developing countries, particularly as regards the provision of technical and financial support. Meaningful cooperation in climate finance represents a necessary implementation of this duty. Moreover, this duty must be informed by the principle of common but differentiated responsibilities, which requires states to conduct consistent efforts to assist developing countries, which, with modalities of climate finance, must evolve to meet the urgency of the climate crisis and considerations of equity. Therefore, states cannot be said to have satisfied their duty to cooperate if they do so through financing mechanisms that place additional burdens on those already most vulnerable to climate impacts, or through processes that create de facto barriers to accessing necessary support. The duty to cooperate in the context of climate finance requires 4 fundamental transformations. First, access to climate finance must be simplified and expedited. The current bureaucratic barriers to accessing climate funds constitute a de facto limitation on developing states' ability to implement necessary climate measures. The duty to cooperate requires paying heed to the special needs of developing countries and ensuring that international cooperation enables effective implementation of treaty obligations. Second, as Bolivia emphasized at the COP29, climate finance must prioritize grants over loans and greater use of special drawing rights as debt-free financing options. This approach aligns with the established principle that cooperation must flow primarily from developed to developing countries and cannot be reduced to merely voluntary or solidarity measures. The obligations to provide financial resources represent an authentic interpretation by the parties of their obligations previously established in the climate change treaties. Moreover, the practice of providing climate assistance primarily through debt instruments effectively transferred the burden of climate actions to those less responsible for the crisis and undermines rather than respect the principle of common but differentiated responsibilities. Third, developing countries have an obligation to provide financial assistance, technology and support. The establishment and operationalization of the Loss and Damage Fund represent practical implementation of this obligation and constitute a core requirement. Fourth, the established obligation to cooperate requires meaningful participation and engagement in relevant processes. This obligation to cooperate meaningfully and in good faith includes participation in both technically and financial processes to support developing countries. In the context of climate change, this duty must be implemented in line with the principle of common but differentiated responsibilities, meaning states with greater capacity should conduct consistent efforts to cooperate with and assist other states in their fight against climate change. Mr. President, the plurinational state of Bolivia submits that the Court advisory opinion should recognize that the adequacy of climate finance in terms of both quantity and accessibility is integral to assessing compliance with international obligations regarding climate change. This includes both procedural obligation and substantive obligations to provide meaningful support. The implications are clear. Developed states cannot claim to be meeting their international obligations while maintaining systems of climate finance that are inadequate, effectively inaccessible for those most in need, or while imposing additional debt burdens on developing states for addressing a crisis they did not create. For the avoidance of any doubt, the duty to cooperate and the rules of state responsibility operate in a complementary rather than mutual exclusive manner. As evidenced by numerous states' submission, the existence of cooperative frameworks in the climate regime does not displace the application of the general rules. The complementary nature of this obligation is particularly evident in the context of climate finance. Voluntarily contribution to cooperative mechanism cannot satisfy or substitute for the legal obligation of developed countries to provide compensation for harm caused by international wrong acts. As multiple states have emphasized, the distinction between voluntary cooperative mechanism and legally binding obligation of reparation must be maintained. The practice of cooperation through climate finance mechanism must therefore be understood as operating alongside rather than replacing obligation arising from state responsibility. Moreover, Mr. President, maintaining the distinction between cooperation and responsibility is essential for the effectiveness of the climate regime. If cooperative mechanisms were to be understood as displacing responsibility, this would undermine both the deterrent effect of state responsibility and the voluntary nature of cooperation. The Court should therefore affirm that while states must engage in good faith cooperation to address climate change, such cooperation operates in addition to, not in place of, their responsibility for international wrongful acts. Mr. President, members of the Court, that concludes my statement on behalf of the plurinational state of Bolivia. I should like to thank the Court for its careful attention.
I thank the representative of Bolivia for his presentation. I now invite the delegation of Brazil to make its oral statement, and I call upon His Excellency Luis Alberto Figueiredo Macato to take the floor.
Thank you. Mr. President, members of the Court, I am deeply honored to appear before this distinguished Court today. It's been Brazil's long-standing policy to support the International Court of Justice, to stand up for the rule of law in international affairs, and to embrace multilateralism and international cooperation to combat climate change. As we prepared to host next year the 30th Conference of the Parties to the UN Framework Convention on Climate Change, I take personal pride in representing my country in these proceedings, which aim to deepen our collective understanding of states' obligations regarding climate change. At the outset, I would like to thank the government of Vanuatu for the initiative of bringing this fundamental issue to the consideration of the Court. In these opening remarks, I will outline Brazil's perspective on climate change and the notion of historical responsibilities that underpins it. Brazil is acutely aware of the devastating impacts of climate change. Our people have been enduring extreme weather events, from severe droughts in the north to relentless rain and floods in the south. Intense forest fires have ravaged vital biomes such as the Amazon, the Cerrado, and the Pantanal. Sadly, these extreme events disproportionately affect our most vulnerable populations. Our vision for the next decades is deeply rooted in the principle of climate justice. At its core, climate justice seeks to combine environmental protection and social inclusion, ensuring that individuals, economies, and nature interact sustainably. On a global scale, it requires prioritizing the needs of the most vulnerable, those who have contributed the least to climate change but bear its heaviest burden, including indigenous peoples, traditional communities, women and children. This vision reflects the broader tenet of common but differentiated responsibilities and respective capabilities, CBDR-RC. Each nation must contribute to combating climate change in proportion to its socio-economic capacity and historical role in global emissions. Furthermore, to achieve climate justice, our collective action must address inequalities, both among nations and within them, leaving no one behind. Brazil, as a developing country, still faces significant socio-economic challenges. Ranking 89th in the Human Development Index, our primary focus remains eradicating poverty, hunger, and inequality. In 2022, 12.7 million Brazilians lived in extreme poverty, with government social programs accounting for 67% of the household income for this population segment. Despite these challenges, Brazil has demonstrated ambition and leadership. Last month, we unveiled a new and enhanced nationally determined contribution, NDC, pledging to reduce greenhouse gas emissions by 59 to 67% by 2035, compared to 2005 levels. This represents a 13 to 29% increase in ambition compared to our previously established 2030 target. Our range-based target allows flexibility to adapt to evolving economic conditions, international cooperation, and technological progress. Brazil's commitment, reflected in its new NDC, extends far beyond what could be reasonably expected based on our historical responsibility for global temperature rise. As a developing country with multiple economic and social challenges, we have nevertheless adopted an economy-wide absolute emissions reduction target. The ambition, scale, and scope of Brazil's effort reflect a level of ambition that often surpasses those of historically high-emitting developed countries. This is the ambition of a nation that faces much higher costs of capital and less fiscal space than developed countries to finance its just transition towards low-carbon and climate-resilient development. Mr. President, the issue of historical responsibilities has been a recurring theme in these procedures. I wish to address its scientific basis. The Intergovernmental Panel on Climate Change, in its sixth assessment report, acknowledges that global greenhouse gas emissions have risen sharply since the Industrial Revolution. These emissions have disproportionately resulted from unsustainable energy use, land use change, lifestyles, and patterns of consumption and production in developed regions. The warming we face today is predominantly the result of historical emissions accumulated over the last 250 years. According to science, the causality link between greenhouse gas emissions and global warming involves a three-step process. First, emissions increase atmospheric concentrations of greenhouse gases. Then, the higher concentration drives temperature rises, which in turn result in associated harm. However, this is not a linear process, but rather a dynamic interaction in which past emissions contribute exponentially more to current global warming than present-day emissions. Moreover, historical emissions have significantly depleted the remaining carbon budget, which is the amount of greenhouse gases that can still be emitted while limiting warming to 1.5 or well below 2 degrees Celsius as required by the Paris Agreement. IPCC has estimated that approximately 45% of historical greenhouse gas emissions remain in the atmosphere today. The unequal appropriation of the global carbon budget by developed countries not only creates new constraints to the economic and social development of developing countries, but also dramatically affects the livelihoods of the most vulnerable populations. Thus, the main provision differentiated between developed and developing countries, enshrined in the three core instruments of the climate regime, the UNFCCC and the instruments adopted thereunder, namely the Kyoto Protocol and the Paris Agreement, reflect not only different capabilities and circumstances, but also varying historical responsibilities. Climate justice demands that nations benefiting the most from historical emissions that still deplete the global carbon budget must bear the greater burden in addressing climate change. Mr. President, our legal advisor will take you through the main elements of our legal reasoning. He will comment on topics that may hopefully assist the Court in rendering its opinion. I must point out that legal issues not covered in this intervention, such as the strong relationship between climate change and human rights, cannot be construed as unimportant to us, or that Brazil agrees to a particular legal reasoning we are not commenting on. I would now most kindly ask you, Mr. President, to invite Professor Jorge Galindo to continue the presentation of Brazil's case. I thank you very much for your attention.
I thank His Excellency Luis Alberto Figueiredo Bocado. I now give the floor to Professor Jorge Galindo. Professor, you have the floor.
Mr. President, members of the Court, Brazil concurs with many states that the advisory opinion requested by the General Assembly through Resolution 77/276 raises issues of international law of paramount importance. These questions fall within the Court's jurisdiction, and we trust the Court will provide its invaluable guidance. In its written comments, Brazil stressed the centrality of the principle of common but differentiated responsibilities and respective capabilities to the advisory opinion to be delivered by this Court and to the climate change international legal regime as a whole. Brazil views the CBDR-RC principle as the cornerstone of the international climate change legal framework. This principle underpins the UNFCCC and the two instruments adopted under it, namely the Kyoto Protocol and the Paris Agreement, ensuring equity in both interpretation and implementation. In many senses, it is the translation of the idea of historical responsibilities to international legal terms. The fact that many states in their written comments refer to it as the cornerstone of the regime or its core principle is not a rhetorical statement. Such comments represent a strong opinion juris that recognizes the centrality of the principle. The International Tribunal for the Law of the Sea, in its last advisory opinion on climate change and international law, was straightforward in recognizing the principle as established in the UNFCCC and the Paris Agreement thereunder as, and I quote, a key principle in their implementation, end of quote. The Paris Agreement states unequivocally, and I quote, this agreement will be implemented to reflect equity and the principle of common but differentiated responsibilities and respective capabilities in the light of different national circumstances, end of quote. It is clearly a principle paramount to the entire implementation of that agreement. The reason for differentiation in the Paris Agreement and previous treaties on climate change is more than evident. States have historically contributed differently to anthropogenic emissions of greenhouse gases and have distinct capabilities and resources to prevent and cope with the adverse effects of climate change. The Paris Agreement did not diminish the CBDR-RC principle. Rather, it expanded the ambition and commitments of all parties. Developed countries must take the lead, reflecting their historical responsibilities and greater capabilities. In this sense, developed nations which historically emitted the most greenhouse gases must lead by achieving net zero emissions earlier, investing in transformative technologies and providing financial and technical support for developing nations to fulfill their commitments. Brazil sees no reason why the court's case law on the obligations of states to prevent transboundary harm should not be applicable in the domain of climate change. These are undoubtedly due diligence obligations and thus obligations of conduct. Since due diligence obligations can only be understood on a case-by-case basis, differentiation among states must be considered while assessing the reach of such obligations. In other words, the CBDR-RC principle is widely applicable in due diligence obligations under the climate change international legal regime. We understand that the CBDR-RC principle does not exempt developing states from their obligations of due diligence. However, this does not mean that due diligence expected from developing states will be the same conduct expected from developed states. Differentiation still applies. In the history of negotiations of all climate change treaties, differentiation has always preceded the idea of setting international legal obligations. Once more, the International Tribunal for the Law of the Sea, in its advisory opinion on climate change and international law, properly understood the issue by stating that the implementation of the standard of due diligence, and I quote, may vary according to states' capabilities and available resources. Such implementation requires a state with greater capabilities and sufficient resources to do more than a state not so well placed, end of quote. This court's Pope Mills case corroborates such understanding of the International Tribunal for the Law of the Sea by referring to the term, and I quote, the means at its disposal, end of quote, in its paragraph 101. Regarding the types of obligations a state has in the climate change international legal regime, Brazil wants to stress that these treaties also establish obligations of result. That is the case, for example, of Article 9.1 of the Paris Agreement, one that undoubtedly establishes the legal obligation of developed states parties to, and I quote, provide financial resources to assist developing country parties with respect to both mitigation and adaptation in continuation of their existing obligations under the Convention, end of quote. This obligation is of the utmost importance for the Court to emphasize in its advisory opinion, especially considering that the recent COP29 once more showed the centrality of financial resources to tackle the harmful effects of climate change in all parts of the world. Mr. President, Brazil highlights that the core climate change international legal regime treaties are the UNFCCC, as well as the Kyoto Protocol and the Paris Agreement adopted thereunder. They fulfill different and complementary regulatory functions. Although a few states are not parties to the Kyoto Protocol, it is undeniable that those treaties were framed to form the basis of the regime. Obligations arising from those treaties are essential to tackle the harmful effects of climate change. The climate change legal regime must be understood and applied in an integrated and systemic way. It is a matter of fact that the Kyoto Protocol and the Paris Agreement were adopted under the UNFCCC. They support and enhance the core provisions of the Convention. It is self-evident that they do not replace the UNFCCC or revoke it. Quite the opposite. As set out in Article 2.1, the very purpose of the Paris Agreement is to enhance the implementation of the Convention, including its ultimate objective. Financial obligations by developed countries under the Paris Agreement are expressly, and I quote, in continuation of their existing obligations under the Convention, end of quote, as I mentioned above. From Brazil's perspective, the treaties composing the climate change international legal regime provide for cooperation among states and establish a genuine duty of cooperation in light of the CBDR-RC principle. Such a duty may be found in several parts of the UNFCCC. Still, Article 4 of the Convention clearly shows how essential cooperation is to the fulfillment of all obligations of the climate change regime, both for mitigation and adaptation. References to cooperation in instruments such as the Kyoto Protocol and the Paris Agreement shall be read in light of the essential role the UNFCCC attributes to cooperation as a duty of states. Brazil would like to point out 4 remaining issues. We understand that the Court should address the following issues in its advisory opinion. First, it is time for the Court to recognize the legal value of at least some of the decisions of the conferences of the parties to the climate change international legal regime. They can at least constitute agreements and subsequent practice for the interpretation of the treaties composing the regime in the sense of Article 31(3) of the Vienna Convention on the Law of Treaties, one of a customary nature. Judge Charlesworth's opinion in the whaling in the Antarctic case before this court suggested such an understanding. Specifically, Brazil believes that the decisions of the COPs, which established, in light of the CBDR-RC principle, the need for developed countries to mobilize resources to address the adverse effects of climate change in developing countries, represent an authentic interpretation by the parties of their obligations previously established in the climate change treaties. Second, the use of specific terms in climate change treaties such as may or will is not the only factor determining whether provisions should be viewed as binding. Assessing the intention of parties while adopting those terms is essential to determining the binding character of a given provision. Third, Brazil is concerned about some states' growing use of climate change rhetoric to breach free trade obligations. In this regard, it is useful to recall that, according to the General Agreement on Tariffs and Trade, GATT, and the World Trade Organization, WTO case law, trade-related environmental measures must not, as a rule, result in discrimination between like products. On similar lines, UNFCCC Article 3.5 provides that, and I quote, measures taken to combat climate change, including unilateral ones, should not constitute a means of arbitrary or unjustifiable discrimination or a disguised restriction on international trade, end of quote. Fourth, although we recognize how complex causality-related issues are in climate change, Brazil has already proposed a methodological work to enable state parties to climate change treaties to quantify their national historical responsibility to global warming. Contrary to what some states argued, such a methodology is scientifically possible and feasible. In conclusion, Mr. President, Brazil wants to emphasize its full commitment to international cooperation and multilateralism to combat climate change. Our vision on the issue is grounded in the idea of climate justice, and we expect that the Court will contribute to making climate change a central topic to the rule of law in international affairs, taking into due consideration the importance of historical responsibilities for the climate crisis. Brazil reputes the CBDRC as a central legal principle to the whole international legal regime. Obligations in that regime must be of conduct, but also of result. While the UNFCCC, the Kyoto Protocol, and the Paris Agreement are the core treaties of the regime, the latter two were established under the first and must be interpreted in light of it. Furthermore, a duty of cooperation, especially from developed states towards developing states, is key to the regime. Additionally, Brazil expects that the Court recognizes that COP decisions, especially those related to the need for developed countries to mobilize resources to address the adverse effects of climate change, are at least subsequent agreements and subsequent practice regarding the interpretation of treaties. We also expect that the Court recognizes that intention, instead of the mere usage of some terms, determines the binding character of provisions in climate change treaties. The Court should also recognize that climate change may not excuse states from breaching their free trade obligations. Moreover, a methodology to assess past emissions is possible and feasible. Finally, Brazil avails itself of the possibility of responding to further questions posed by this Court in written form at a later stage. I thank you very much indeed, Mr. President.
I thank the President of Brazil for their presentation. Before I invite the next delegation to take the floor, the Court will observe a break of 15 minutes. The hearing is suspended. Veuillez vous asseoir. L'audience reprend. J'invite maintenant la délégation du participant suivant, le Burkina Faso, à prendre la parole et appelle son Excellence Léopold Borkouniou à la barre.
Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les membres de la Cour, c'est un honneur pour moi de paraître devant votre haute juridiction au nom de mon pays, le Burkina Faso. Pays résilient de la région du Sahel, le Burkina Faso est profondément attaché à l'idéal de la justice par le droit. C'est pourquoi mon pays reste un fervent soutien de la Cour et n'a jamais hésité à se présenter devant elle. Aujourd'hui, la même confiance habite le Burkina Faso. En effet, la présente procédure consultative pose un problème élémentaire de justice. Les émissions anthropiques de gaz à effet de serre dues aux actes et aux omissions d'un nombre limité d'États ont causé des dommages significatifs et multiformes au système climatique, faisant reposer le fardeau le plus lourd de leurs effets néfastes sur des États comme le Burkina Faso, qui y sont complètement étrangers et ne peuvent y faire face seuls. Ces faits, bien connus, forment la trame de la présente procédure et n'ont été contestés par aucun participant. Ils sont corroborés par les rapports du groupe intergouvernemental sur l'évolution du climat, dont les conclusions jouissent, en vertu des critères établis par votre jurisprudence, de la plus haute valeur probatoire. Le cas de Burkina Faso est symptomatique de cette injustice. Selon certaines évaluations, le Burkina Faso n'a contribué qu'à hauteur de 0,12% aux émissions globales de gaz à effet de serre. Pourtant, les déterminants clés de son développement, à savoir les ressources en eau, l'agriculture, l'élevage, les ressources halieutiques, la santé, l'énergie, les infrastructures et l'habitat, sont tous déjà gravement affectés par les effets néfastes des émissions de gaz à effet de serre et les changements climatiques y afférents. Selon le GIEC, l'économie burkinabé a perdu entre 1991 et 2010 plus de 20% de son produit intérieur brut par individu du fait des effets néfastes des changements climatiques causés par les émissions anthropiques des gaz à effet de serre. L'avenir est plus que sombre. Le Burkina Faso est le 29e État le plus vulnérable au changement climatique et le 158e État le mieux préparé pour y faire face. L'action climatique, y compris celle de la présente Cour, est plus qu'urgente. Monsieur le Président, les changements climatiques, ce n'est pas seulement l'élévation du niveau de la mer. Chronologiquement, la désertification fut la première catastrophe climatique. Les membres de la Cour se rappellent sans doute la grande sécheresse de 1973. Celle-ci arrive exactement 2 décennies après le début de l'augmentation vertigineuse des émissions de gaz à effet de serre. L'Assemblée générale des Nations unies l'avait qualifié de tragédie et avait appelé à assister et à soutenir la région soudano-sahélienne. Le Burkina Faso avait, dès le début des années 1980, notamment à travers le président Thomas Sankara, dénoncé les pollutions déversées dans la nature qui perturbent l'ordre établi des choses. Le président Sankara avait appelé à la responsabilisation de, je cite, tous ceux qui, loin de chez nous, provoquent de façon directe et indirecte les perturbations climatiques et écologiques. Fin de citation. En 1986, lors de la conférence de Paris sur la forêt et l'eau, il avait proposé, je cite, qu'au moins 1% des sommes colossales sacrifiées dans la recherche de la cohabitation avec les autres astres servent à financer de façon compensatoire les projets de lutte pour sauver l'arbre et la vie. Fin de citation. Tant l'alerte donnée que les solutions proposées par le Burkina Faso furent ignorées. Depuis la sécheresse de 1973, tout le Sahel, cette bande désertique allant du Sénégal à la Somalie, en passant par la Mauritanie, le Mali, le Burkina Faso, le Niger, le Tchad, le Soudan, l'Éthiopie, l'Érythrée et Djibouti, est traversée par des conflits internes qui hypothèquent tout espoir de développement. Tant pour le Conseil de sécurité que pour le GIEC, les changements climatiques et partant les émissions de gaz à effet de serre sont l'une des causes de ces conflits, de leur fréquence, de l'augmentation de leur durée et de l'intensification de leur degré de violence. Monsieur le Président, face à cette grave injustice, le Burkina Faso place sa confiance dans le droit international et en la Cour, qui est la voie la plus autorisée. Le Burkina Faso se réjouit qu'aucun État n'ait véritablement contesté la compétence de la Cour pour rendre le président avis consultatif. Quelques États ont timidement suggéré que la Cour devait examiner prudemment les questions posées. Ils ont prétexté notamment les négociations en cours sur les changements climatiques. Tous les arguments soulevés dans ce contexte se heurtent à la jurisprudence établie de la Cour. Le Burkina Faso ne les examinera pas, donc pas davantage. Pour le Burkina Faso, la Cour doit contribuer, conformément à la Charte, à l'œuvre des Nations Unies, dont elle est l'organe judiciaire principal. Elle doit exercer sa compétence comme à son habitude et éviter de donner une réponse incomplète qui serait inefficace et risquerait d'induire en erreur l'Assemblée générale sur l'étendue et la portée des obligations pertinentes. La Cour doit donc, en vertu de la question A, indiquer toutes les obligations des États en matière d'émissions anthropiques de gaz à effet de serre et, en vertu de la question B, clarifier toutes les conséquences juridiques de leur violation. Ce faisant, elle doit mettre un accent particulier sur les préjudices humains, environnementaux et socio-économiques résultant de la désertification due aux émissions anthropiques de gaz à effet de serre. Je voudrais, Monsieur le Président, vous remercier pour votre aimable attention et vous prier de bien vouloir passer la parole au professeur Mamadou Ebié qui fournira à la Cour quelques éléments de réponse aux deux questions posées par l'Assemblée générale.
Je remercie Son Excellence Léopold Boncougnou. Je passe maintenant la parole au professeur Mamadou Ebié.
Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les membres de la Cour, c'est un grand honneur pour moi de paraître devant votre haute juridiction et de le faire au nom de mon pays, le Burkina Faso. Je vais examiner à tour de rôle les deux questions qui ont été posées par l'Assemblée générale. Mais avant toute chose, le Burkina Faso observe que tous les participants à la présente procédure reconnaissent que le droit international impose des obligations aux États et qu'il y attache des conséquences juridiques à leur violation. Aucun ne soutient que les émissions de gaz à effet de serre évoluent dans un vide juridique. En revanche, et c'est la contradiction principale dans la présente procédure, certains États allèguent, sur le fondement de la doctrine de la lex specialis, que seulement la Convention cadre des Nations Unies sur les changements climatiques, le protocole de Kyoto et l'accord de Paris sont les seuls éléments du droit applicable, tant pour le contenu des obligations que pour les conséquences juridiques de leur violation. Cependant, aucun de ces participants n'a apporté la preuve d'une dérogation expresse à toutes ces règles du droit international. Aucun n'a apporté la preuve d'une dérogation implicite à ces règles, comme cela est requis par le droit international. Pour ces participants, le simple fait de la conclusion de ces traités sur les changements climatiques serait en lui-même la preuve de l'intention implicite de déroger à toutes les normes primaires du droit international et à toutes les normes secondaires, y inclus les obligations erga omnes et les règles du jus cogens. La Cour, qui a fait preuve de beaucoup de réserves à l'égard de la doctrine de la lex specialis, ne saurait accepter cette pétition de principe. Les dispositions des conventions onusiennes elles-mêmes indiquent qu'elles se soutiennent mutuellement avec les autres obligations du droit international, notamment celles qui protègent les droits humains et l'environnement marin. Par ailleurs, selon la jurisprudence de la Cour, la renonciation au droit de mettre en œuvre la responsabilité internationale doit être claire et non équivoque. Pourtant, aucune preuve n'a été apportée que tous les pays qui ont adhéré à ces conventions ont renoncé à leur droit de recevoir réparation pour les dommages causés par les émissions de gaz à effet de serre. Certainement pas le Burkina Faso. Le Burkina Faso conclut dès lors que tout le droit international demeure applicable aux questions posées par l'Assemblée générale. Monsieur le Président, je passe maintenant à l'examen de la question A. Celle-ci demande à la Cour de déterminer quelles sont les obligations qui imposent aux États en ce qui concerne la protection du système climatique et d'autres composantes de l'environnement contre les émissions anthropiques de gaz à effet de serre. Monsieur le Président, la question posée par l'Assemblée générale est claire. Elle ne demande pas de déterminer les obligations qui ont été adoptées spécifiquement sur la question des changements climatiques. Elle concerne, je répète, les obligations qui incombent aux États en ce qui concerne la protection du système climatique et d'autres composantes de l'environnement contre les émissions anthropiques de gaz à effet de serre. Pour le Burkina Faso, les obligations concernées sont donc non seulement les obligations dont l'objet principal est la protection du système climatique, que nous avons examinées dans nos écritures, mais également celles qui exigent de façon incidente à ce que l'État protège le système climatique afin de pouvoir se conformer à d'autres de ses obligations, notamment ses obligations de respecter les droits humains, les droits des peuples à l'existence et au développement, ainsi que le droit de coopérer de bonne foi en vertu de la Charte. Toutefois, pour le Burkina Faso, l'avis de la Cour ne doit pas se résumer à un catalogue de toutes ces sources du droit international. La Cour doit, comme par le passé, rendre cette pratique digeste et opérationnelle pour l'Assemblée générale. Elle doit le faire en reconnaissant que ce dense faisceau normatif qui protège à titre principal et à titre incident le système climatique, ainsi que la riche pratique étatique y relative, indique l'existence, dans l'opinion juriste des États, d'obligations coutumières spécifiques aux émissions anthropiques de gaz à effet de serre et leurs effets néfastes dans les changements climatiques. Certaines de ces obligations sont applicables à tous les États, d'autres le sont seulement aux États développés. Les obligations qui sont applicables à tous les États et qui sont donc erga omnes et dont aucun État ne saurait y déroger sont l'obligation générale de protéger et de préserver le système climatique. Et cette obligation générale implique des obligations spécifiques, notamment l'obligation de ne pas causer de dommages importants au système climatique, l'obligation de ne pas aggraver les vulnérabilités existantes du système climatique, l'obligation de ne pas adopter les mesures législatives, administratives ou autres qui facilitent les émissions de gaz à effet de serre par les tiers, y inclut les personnes privées, l'obligation de protéger, conserver et améliorer quantitativement et qualitativement les capacités d'absorption des réservoirs et des puits de gaz à effet de serre, l'obligation de prendre les mesures de prévention nécessaires pour que les activités qui se déroulent sur les territoires des États ne causent pas de dommages importants au système climatique et n'affectent pas la jouissance effective par les autres États, peuples et individus de leurs droits, y inclut les individus en dehors de la juridiction nationale. L'obligation d'adopter les mesures d'adaptation requises pour renforcer la résilience du système climatique et des autres composants de l'environnement face aux effets néfastes des émissions de gaz à effet de serre. Et enfin, l'obligation de coopérer de bonne foi à la résolution des défis posés par les émissions de gaz à effet de serre, les changements climatiques et leurs effets néfastes. Quant aux obligations supplémentaires, qui sont applicables seulement aux États développés, conformément au principe de la responsabilité commune mais différenciée, il s'agit de l'obligation d'être à l'avant-garde de la lutte contre les changements climatiques en prenant les mesures appropriées pour réduire drastiquement leurs émissions de gaz à effet de serre et de l'obligation de fournir l'assistance technique, financière et le transfert de technologies requis par les pays en voie de développement pour que ceux-ci puissent mettre en œuvre leurs obligations en matière de changement climatique, s'adapter aux effets néfastes des changements climatiques et enfin réaliser le droit de leur peuple au développement. Monsieur le Président, je passe maintenant à l'examen de la deuxième question, la question B, qui invite la Cour à déterminer les conséquences juridiques pour les États qui, par leurs actions ou omissions, ont causé des dommages significatifs au système climatique et à d'autres composantes de l'environnement, en violation des obligations ci-avant mentionnées. Pour le Burkina Faso, la question B demande que la Cour établisse seulement le principe de la responsabilité internationale des États qui, par leurs émissions significatives de gaz à effet de serre, ont causé des dommages importants au système climatique. Pour accomplir cette tâche, il n'est point besoin d'identifier individuellement quel État a émis quelle quantité de gaz à effet de serre pour quel dommage à quel partie du système climatique. Ce qu'il faut constater, c'est qu'une immense majorité de pays, dont le Burkina Faso, n'y est pour rien. Et qu'une minorité de pays qui sont relativement identifiés, bien identifiés à l'annexe 1 de la Convention cadre, ont permis l'émission d'une quantité exorbitante de gaz à effet de serre qui a causé des dommages importants au système climatique en violation des obligations applicables à tous les membres de ce groupe. Donc, pour donner avis utile à l'Assemblée générale, la Cour doit seulement répondre à deux questions. Quelles sont les obligations internationales qui sont violées par les actes et omissions des États visés qui ont conduit à des émissions significatives de gaz à effet de serre et les dommages y afférents, et quelles conséquences juridiques s'attachent à ces violations? En réponse à la première question, le Burkina Faso a prouvé dans ses écritures que les États visés par la question B ont violé, et je les liste, premièrement, leur obligation de prendre les mesures de prévention nécessaires pour que les activités qui se déroulent sur leur territoire ne causent pas de dommages importants au système climatique et n'affectent pas négativement la jouissance effective par les États, les peuples et les individus de leurs droits. Ils ont également violé l'obligation d'être à l'avant-garde de la lutte contre les changements climatiques du fait de n'avoir pas réduit drastiquement leurs émissions de gaz à effet de serre. Ils ont aussi violé l'obligation de ne pas adopter des mesures législatives, administratives ou autres qui favorisent ou facilitent les émissions de gaz à effet de serre par des tiers, y inclus par les personnes privées, ainsi que leur obligation de retirer les mesures déjà adoptées. Ils ont en outre violé l'obligation de fournir l'assistance financière, technique et le transfert de technologies requis pour permettre aux pays en voie de développement, et particulièrement les pays affectés par la désertification au Sahel, pour que ces États puissent mettre en œuvre leurs obligations en matière de changement climatique et réaliser le droit de leur peuple au développement. Enfin, ils ont violé l'obligation de coopérer de bonne foi à la résolution des défis posés par les émissions de gaz à effet de serre et les changements climatiques et leurs effets néfastes. Sur ce dernier point, le Burkina Faso n'ignore pas que la bonne foi doit être toujours présumée. Toutefois, cette présomption simple doit être levée pour la question qui nous concerne. En effet, la bonne foi exige que tout État qui est soumis à une obligation internationale s'abstienne de tout acte visant à en empêcher l'exécution ou à réduire son objet à néant. Pourtant, les États visés, au lieu de réduire drastiquement leurs émissions de gaz à effet de serre conformément à leurs obligations, ont accordé des subventions à la production, à la consommation, au transport, au stockage d'énergie fossile, décuplant ainsi les concentrations de gaz à effet de serre et leurs effets néfastes sur le système climatique. Contrairement à la détermination et au dynamisme avec lesquels ils ont fait preuve lorsqu'il s'agissait d'affronter la crise résultant de l'appauvrissement de la couche d'ozone, dont les effets les concernaient plus directement, ici, ils traînent les pieds pour exécuter leurs obligations d'assistance financière, technique et de transfert de technologies qui permettraient aux pays les plus affectés, dont ceux du Sahel, de faire face aux effets néfastes des gaz à effet de serre. Par ailleurs, ils refusent toute réforme du système financier et monétaire international qui permettrait aux États les plus affectés d'utiliser leurs propres moyens pour pouvoir faire face aux périls existentiels auxquels ils sont confrontés. Monsieur le Président, je passe à l'examen de la deuxième question à laquelle la Cour doit répondre pour pouvoir répondre à la question B de l'avis consultatif. Le Burkina Faso soutient que les conséquences juridiques ordinaires du droit de la responsabilité internationale, la cessation, la non-répétition, la réparation pleine et intégrale s'appliquent. Concernant l'obligation de cessation, les États visés doivent premièrement retirer toutes les mesures administratives, législatives et autres, notamment les aides, subventions et autres incitations à la production, au stockage, au transport ou à la consommation d'énergie fossile. Ils doivent prendre toutes les mesures nécessaires pour que les activités qui se déroulent sur leur territoire, notamment celles des compagnies pétrolières, ne causent pas d'émissions de gaz à effet de serre affectant la jouissance effective par les États, peuples et individus de leurs droits. Troisièmement, ils doivent fournir l'assistance technique, financière et le transfert de technologies requis pour que les États en voie de développement, et plus particulièrement ceux affectés par la désertification, puissent faire face aux défis des changements climatiques. En particulier, ils doivent soutenir l'initiative de la Grande Muraille verte, portée à ses débuts par le Burkina et endossée par l'Union africaine en tant que mesure de restauration active de l'environnement, afin de rétablir l'environnement sahélien en son état d'origine. Quatrièmement, ils doivent désormais coopérer de bonne foi à la résolution des problèmes posés par les changements climatiques. Concrètement, ces États, qui sont les principaux architectes du système économique et financier mondial actuel, et en sont les principaux bénéficiaires, doivent prendre l'initiative de sa réforme en suivant en cela les lignes tracées dans la déclaration concernant l'instauration d'un nouvel ordre économique international et la charte des droits et devoirs économiques des États. En effet, la grande majorité des traités qui visent à protéger le système climatique et les autres composantes de l'environnement s'accordent sur le fait que les inégalités du système monétaire, économique et financier actuel constituent un obstacle majeur à l'atteinte de leurs objectifs. S'agissant de la réparation du préjudice causé, les États visés par la question B doivent offrir une indemnisation prompte, adéquate et effective aux États spécialement lésés par la violation de leurs obligations, en accordant priorité aux États frappés par la désertification et aux petits États insulaires en développement. Ils doivent également compenser l'immense préjudice socio-économique causé par les émissions anthropiques de gaz à effet de serre et leurs effets néfastes, dont la désertification y inclut les pertes de produits intérieurs bruts mentionnées plus avant. Enfin, ils doivent, puisque l'obligation de protéger le système climatique est une obligation erga omnes et que son noyau dur, l'obligation de ne pas causer de dommages significatifs au système climatique, est une norme de jus cogens, toutes les conséquences juridiques du régime spécial du droit de la responsabilité internationale sont aussi applicables dans la présente procédure. Monsieur le Président, pour le Burkina Faso, l'heure est venue que la Cour reconnaisse que l'obligation générale de tous les États de protéger et de préserver le système climatique est une obligation erga omnes, opposable à tous les États membres de la communauté internationale. L'heure est également venue de reconnaître que l'obligation de ne pas causer de dommages importants au système climatique est une règle de jus cogens. Monsieur le Président, pour terminer, si nous devions résumer la présente procédure en une simple question, elle serait la suivante, peut-être un peu longue. Un groupe limité d'États peuvent-ils, conformément au droit international, détruire un bien commun indispensable à la survie de l'humanité, je parle du système climatique, pour s'enrichir et déplacer tout le fardeau des effets néfastes de leurs actions sur des États, peuples et individus tiers, tout en remettant toujours à plus tard, sinon à jamais, la question de leur responsabilité et de leur solidarité. La réponse du Burkina Faso, pays des hommes intègres, est non. Non, nul ne peut s'enrichir injustement et se développer économiquement au prix du sacrifice des droits des États, des peuples et des individus tiers. Non, ces États sont tenus par toutes leurs obligations émanant du droit international et de toutes les conséquences juridiques de leurs faits internationalement illicites. Je vous remercie, Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les membres de la Cour, pour votre bienveillante attention.
Je remercie les représentants du Burkina Faso pour leur présentation. J'invite à présent la délégation du Cameroun à prendre la parole et appelle son Excellence Madeleine Liguemo Ondioa à la barre.
Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les juges, honorables membres de la Cour, en vos rangs et qualités. La République du Cameroun, par la voix de son ambassadeur, fait écho des propos d'autres partis pour, une fois de plus, saluer la contribution significative de la Cour à la construction inexorable d'une société internationale fondée sur le respect de la règle de droit. Le rôle de la présente session marque un pas historique en ce sens qu'il appelle votre auguste Cour à se prononcer sur une question d'importance particulière au regard des enjeux climatiques susceptibles d'hypothéquer l'avenir commun de l'humanité. Il s'agit pour la Cour de reconnaître solennellement, puis de consacrer le lien inextricable qui existe entre le changement climatique et les droits humains, et, enfin, d'affirmer la responsabilité des parties dans les faits climatiques constatés. Par conséquent, la Cour devra certes faire sienne le principe de la responsabilité commune, mais différenciée, des États admis en droit international depuis la conférence de Rio, mais surtout inférer les obligations qui en découlent et incombent aux pays développés qui détiennent la très grande majorité de stocks de carbone dans l'atmosphère, avec des pesanteurs sur les progrès humains et économiques des pays en développement. Au nom du Cameroun, c'est un honneur de présenter nos hommages à la Cour et de la remercier pour son apport substantiel à la résolution des différends internationaux ainsi qu'au développement du droit international. La Cour a été particulièrement sollicitée ces dernières années, preuve de la confiance que lui accordent de plus en plus les États. La présente analyse implique aussi l'importance de reconnaître le droit des générations futures dans le contexte des droits des peuples, notamment à la lumière de la Charte africaine des droits humains et des peuples de 1981 et d'autres normes internationales pertinentes. Mr. President, for this noble cause to be heard for our state, the Republic of Cameroon wishes that the court recognizes the crime of ecocide in order to complete the legal framework essential for the recognition of the state responsibility for the environmental disasters described, and, where appropriate, the relating compensatory measures should be deducted. Mr. President, we wish that you give the floor to our legal expert, Barrister Pierre-Olivier Savoy, to present the gist of the legal point defended by the Republic of Cameroon. Thank you for your kind attention.
Je remercie Son Excellence Madeleine Liguemont-Wanda. Et avant de passer la parole à M. Pierre-Olivier Savoy, je voudrais m'assurer qu'il y a un problème technique
They crossed over the channels of translation, but it's okay. We'll pick up.
It's okay now?
I don't know.
Bon. Vous avez la parole, M. Pierre-Olivier Savoy.
Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les juges, c'est évidemment un plaisir et un honneur d'être de retour devant la Cour, à la Cour. La première partie de l'exposé oral du Cameroun devait être présentée par le docteur Mounial Sidi, directeur des affaires juridiques au ministère des Relations extérieures, signataire des observations écrites du Cameroun. Je me vois malheureusement contraint de vous transmettre, de vous présenter ces hommages, car il ne pourra être des nôtres aujourd'hui, ce qu'il aurait vivement souhaité, notamment pour demander à la Cour d'endosser la notion d'écocide. Je vais donc essayer de rendre justice aujourd'hui aux idées et positions que le docteur Sidi voulait présenter au nom du Cameroun et de la nation camerounaise. C'est une grande responsabilité pour moi, dont je vais essayer de m'acquitter avec honneur et respect. J'en profite pour remercier son Excellence, Madame l'ambassadrice du Cameroun, Madeleine Ligmo-Ondoa, pour ses propos introductifs. Je voudrais aussi vous avertir à l'avance que je vais alterner entre le français et l'anglais dans ma plaidoirie, en hommage aux deux langues officielles de la Cour, qui sont aussi celles du Cameroun. Dans un premier temps, la Cour est évidemment compétente pour répondre à la demande d'avis consultatif de l'Assemblée générale. La demande est aussi recevable et le Cameroun remercie à l'avance la Cour pour sa contribution au développement du droit international et au bon fonctionnement de l'Organisation des Nations unies, de par l'avis qu'elle rendra. La première question posée à la Cour lui demande d'identifier les obligations qui incombent aux États en ce qui concerne la protection du système climatique, incluant pour les générations présentes et futures. Il existe des obligations liées à la protection du système climatique dans de nombreuses conventions internationales, au-delà de celles spécifiquement sur le sujet. Nous les avons mentionnées dans les observations écrites du Cameroun. Elles incluent la Charte des Nations unies, le Pacte international relatif aux droits civils et politiques, le Pacte international relatif aux droits sociaux, économiques et culturels, la Convention cadre des Nations unies sur les changements climatiques, l'accord de Paris bien sûr, et la Convention des Nations unies sur le droit de la mer. Les obligations suivantes incombent aussi aux États en la matière. L'obligation de diligence requise, et nous soutenons les observations du Brésil de ce matin sur l'obligation de due diligence, les droits reconnus dans la Déclaration universelle des droits humains, le principe de prévention des dommages significatifs à l'environnement, incluant les dommages transfrontières, et l'obligation de protéger et de préserver le milieu marin. Le Cameroun veut aussi attirer l'attention de la Cour sur un type d'obligation reconnue, et j'insiste sur le mot reconnu plutôt que créé, par l'accord de Paris, parce que ces obligations doivent être considérées comme existant en plus et indépendamment de cet accord. Il s'agit des obligations différenciées et des capacités respectives mentionnées aux articles 2, 4, notamment de l'accord de Paris. Ces obligations sont importantes pour le Cameroun et il en découle des conséquences significatives sur lesquelles nous invitons la Cour à fournir l'élaboration nécessaire. En effet, les pays africains et les autres pays en voie de développement ne sont pas à l'origine de la crise climatique et n'ont pas non plus bénéficié des avantages économiques résultant des niveaux élevés d'industrialisation. Les pays développés doivent aussi assurer un soutien financier aux pays en voie de développement afin de les aider à atteindre les objectifs climatiques. La Cour est invitée à clarifier autant que possible les obligations financières des pays développés en ce sens. Il faut aussi aborder le droit des générations non seulement présentes, mais aussi futures. Le droit des générations à venir a été reconnu par la Cour dès son avis consultatif sur la licéité de la menace ou de l'emploi d'armes nucléaires en 1996. La Cour s'est aussi référée au principe d'équité intergénérationnelle dans son arrêt Gapchikovo-Naguimaros en 1997. Il y a maintenant 14 ans, le juge Cansado Trindade énonçait un principe que la Cour pourra certainement reconnaître aujourd'hui. De nos jours, en 2010, on ne peut guère douter que la reconnaissance de l'équité intergénérationnelle procède de la sagesse conventionnelle en droit international de l'environnement. Un grand nombre de traités et d'autres instruments internationaux que nous énumérons dans nos observations écrites et qui incluent l'accord de Paris se réfèrent aussi au principe de l'équité intergénérationnelle. Il faut aussi rappeler que le Cameroun a porté à l'attention de la Cour la Charte africaine des droits humains et des peuples et en particulier ses articles 19 à 24 sur l'égalité des peuples. Vous avez avec vous un extrait de cette pièce 1, la Charte africaine dans ses versions françaises et anglaises. Les articles 19 à 24 que vous avez devant vous sont pertinents non seulement sur l'équité intergénérationnelle, mais aussi parce qu'ils confirment de larges obligations existantes en matière d'obligations communes mais différenciées, comme je le mentionnais plus tôt, au-delà des termes de l'accord de Paris. Sur le droit des générations futures, la Cour pourra s'inspirer de la tradition africaine de droit international, notamment des principes énoncés à l'article 24 de la Charte africaine. Celui-ci prévoit en français que tous les peuples ont droit à un environnement satisfaisant et global, propice à leur développement. Et en anglais, all peoples shall have the right to a general, satisfactory environment favorable to their development. Qui dit droit des peuples dit nécessairement droit des générations futures, qu'il faut considérer dès aujourd'hui. Les observations du Vanuatu d'hier allaient certainement dans ce sens. C'est une des raisons pour lesquelles le Cameroun invite la Cour à reconnaître la notion d'écocide, ainsi que les conséquences juridiques qui doivent découler d'un tel acte. Pour le Cameroun, il existe certainement une norme impérative de droit international à l'effet que nulle personne, physique ou morale, ne peut commettre ou laisser commettre des actes d'une telle gravité qu'ils pourraient être considérés comme pouvant mener à la destruction de l'environnement, de la planète ou des peuples ou de leur territoire, notamment si leur environnement est menacé. Le niveau de gravité requis pour constituer un écocide devra être jugé au cas par cas et pourra évoluer avec le temps. Ce qui est certain aujourd'hui est qu'un tel niveau de crime ou de violation du droit international se doit d'exister et que de telles actions pouvant mener à la destruction de la planète ou des peuples ou de leur territoire se doivent d'être prohibées comme telles. La Cour pourra reconnaître que des actes graves d'une telle nature mettraient évidemment en œuvre le régime de l'article 41 des articles sur la responsabilité des États requérant la coopération de tous les États pour mettre fin à une telle violation ou situation et toutes les autres conséquences qui en découlent. Nous avons aussi noté la référence au ius cogens du Burkina Faso, qui peut-être en un sens dit un peu la même chose. La reconnaissance d'un tel régime de responsabilité requérant aussi aux États d'exercer leur juridiction pénale sur les individus concernés, dans la mesure où cela serait pertinent, est aussi dans l'intérêt des générations futures. Cet intérêt inclut aussi la nécessité de transferts financiers substantiels vers les pays en voie de développement pour rencontrer les objectifs climatiques. Comme le Cameroun l'a déjà indiqué, la Cour est invitée à se pencher autant que possible sur le détail de ces obligations. Dans l'intérêt des générations futures, il pourra aussi être approprié pour la Cour de souligner l'importance des obligations anticorruption applicables à tous les États afin d'assurer un bon fonctionnement du système de protection climatique et une transition énergétique appropriée, tel que le Cameroun l'a indiqué dans ses secondes observations écrites. C'est maintenant le temps de passer de la langue de Laferrière et Senghor à celle de Mandela, Mboué et Morrison. I will address three further issues. First, I will address the importance of the human rights framework in relation to climate change obligations. Second, I will address certain issues arising from state responsibility and the consequences stemming from violations of obligations related to climate change. Finally, I will conclude on the interaction between international law for the protection of foreign investment and international law obligations on climate change, a subject on which Cameroon believes the court could help clarify legal obligations and the hierarchy of norms in the interest of a good and proper energy transition. In respect of human rights, Cameroon invites the court to recognize the links between climate change and human rights obligations. For Cameroon, paragraph 11 of the preamble of the Paris Agreement, which recalls that parties should, when taking action to address climate change, respect, promote, and consider their respective obligation on human rights, actually applies more generally, and in reality stems from and reflects an independent, binding obligation on all states to do so. There is no conflict for Cameroon between human rights obligations and climate change obligations, since the relationship is one of both interpretation and integration. The same applies to other international obligations, whether conventional or customary, outside the climate change agreement agreement's framework. Cameroon respectfully requests the court to recognize the impact of climate change on human rights, in particular the right to self-determination, which includes the right to territorial integrity, as recalled by our friends from island nations yesterday, the right to life, the right to access to water, the right to food, the right to health, the right to private and family life, and the right to development. Moreover, the court should also recognize the repercussions of climate change on these rights, and that such repercussions are all the more significant for vulnerable persons. With respect to specifically the right to development, Cameroon would like to associate itself with the position of the African Union that the right to development must be interpreted in the light of the objective of eradicating poverty, an issue referenced by Brazil earlier today, which is essential for sustainable development. Cameroon would also like to associate itself with the request from the European Union that the court confirm the existence of the right to a healthy environment as a customary international law norm. Cameroon recalls, again, because it is important, that Article 24 of the African Charter of Human and People's Rights confirms a right of all peoples to a general satisfactory environment favorable to their development. The African Commission on Human and People's Rights has significantly developed this right, as underscored in Cameroon's second written submission. J'aimerais maintenant me pencher sur quelques éléments concernant la responsabilité des États. Pour le Cameroun, les conséquences juridiques découlant de la violation des obligations concernant le régime de protection climatique s'analysent au regard du droit général de la responsabilité des États, tel que reflété dans les articles sur la responsabilité des États pour faits internationalement illicites. Il existe, en tous les cas, plusieurs obligations coutumières qui s'appliquent au régime de protection climatique tel que déjà énuméré. Leur violation entraîne la responsabilité en vertu du régime général de responsabilité. Il est important, Monsieur le Président, que la Cour le confirme. Le Cameroun considère aussi qu'il existe une différenciation entre les pays développés et les pays en voie de développement, qui sont plus vulnérables aux conséquences du changement climatique et qui ont contribué de manière marginale aux émissions de gaz à effet de serre. Ainsi, au regard de la contribution historique des pays développés, les pays en développement, premières victimes des changements climatiques, devraient recevoir une indemnisation pour les préjudices subis. L'indemnisation comme forme de réparation joue un rôle essentiel pour soutenir les pays en développement dans leurs actions. Elle peut s'opérer par le biais de fonds dédiés ou autrement. I will now discuss my third point. The interaction between states' compliance with international climate change obligations and international obligations pertaining to the protection of foreign investment. To recall, the first question to be addressed by the court is, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and present and future generations? As the court has held before, it can rewrite advisory questions posed to it or reinterpret them when answering the question. That said, what Cameroon will now outline are obligations, including how they are to be applied in relation to the protection of the climate system. In its second submission, Cameroon brought to the court's attention the Continental African Free Trade Area Investment Protocol, its Exhibit 12, which you have with you, adopted by 54 African countries in October 2022. We have provided you with an extract, as I mentioned, so you can read it for yourself and look at Article 24, which we will examine together. We have provided the 2022 final version adopted by states parties, as well as a later 2023 identical text in French and English. What matters for our climate change purposes is that relevant parts of the treaty, and in particular its Article 24, because of how it is drafted, reflects a consensual position of all 54 African states from which the court can and should draw conclusions. The text of Article 24, Right to Regulate, of the CAFTA Investment Protocol provides, in accordance with customary international law and other general principles of international law, each state party has the right to regulate, including to take measures to ensure that investment in its territory is consistent with the goals and principles of sustainable development and with other national in the English, or legitimate in the French, so with other national legitimate environmental, health, climate, the word we're looking for, social and economic policy objectives and essential security interests. And now let's note the next three words: for greater certainty. Measures taken by a state party to comply with its international obligations under the relevant treaties, like the Paris Agreement or the other treaties we've mentioned, do not constitute a violation of this protocol. Then it says, for the avoidance of doubt, the exercise of the right to regulate under paragraphs 1 and 2 shall not give rise to any claim by an investor for compensation. So, the measures adopted to ensure the compatibility of investments with the objectives and principles of sustainable development and other good faith, national, legitimate environmental, health, climate policy objectives do not violate the investment protection obligations of the Pan-African Investment Protocol, or in essence, international investment obligations more generally, and cannot give rise to compensation. Article 24 uses the words "il est entendu" in French and "for greater certainty" in English to recall that compliance with climate obligations is not a breach of investment protection obligations, as reflected by other Cameroonian treaty practice pointed out in Cameroon's second written submission. Il est entendu and "for greater certainty" in treaty drafting means that the parties having concluded a treaty containing such terms consider that the relevant obligation or principle referred to applies, even absent a treaty obligation. Article 24 of the Investment Protocol of the African Continental Free Trade Agreement therefore demonstrates a continent-wide view that the rules I have referred to apply even in the absence of treaty standards. The application, in good faith, of legitimate climate obligation, like the Paris agreements or the other agreements we have, or other rules that we have talked about by states, therefore cannot lead to breach of investment protection obligations and the grant of compensation. Cameroon, as one of the 54 African states, therefore considers that this norm generally reflects custom. The court, or judges, in any individual opinions, are thus invited to recognize at least a regional custom applicable to the entire African continent, and possibly a larger universal one. To this effect, whether or not the CAFTA or any other treaty is directly applicable. That is, a good faith application of climate obligations cannot lead to a breach of foreign investment protection obligations or compensation. Such clarification from the court would be very helpful for states' implementation of the right to regulate, in the application of climate obligations, and, as such, the protection of the climate system. Pour terminer, Monsieur le Président, Madame la Vice-présidente, Vos Excellences, Mesdames et Messieurs les juges, j'aimerais vous remercier pour votre attention. En guise de conclusion, j'aimerais ajouter ce qui suit. Vous aurez peut-être l'impression cette semaine et la semaine prochaine que les plaidoiries se suivent et se ressemblent sur le contenu. Mais cela est une vertu, sans rien enlever à la créativité et l'ingéniosité des différentes plaideuses et plaideurs dans le grand hall de la paix. S'il y a un sentiment de déjà-vu d'un plaideur à l'autre, d'une plaideuse à l'autre, c'est tout simplement parce que nous avons essentiellement un consensus sur une majorité de points d'importance capitale pour l'humanité et l'avenir de la planète, des peuples, des Nations unies et des générations présentes et futures. Ce consensus, la Cour saura certainement le rappeler dans son avis consultatif, et pour cela, la République du Cameroun vous en remercie à l'avance. Merci, Monsieur le Président.
Je remercie les représentants du Cameroun pour la présentation. I now invite the delegation of the Philippines to address the court, and I call upon His Excellency Eduardo Malaya to take the floor.
Mr. President, distinguished members of the court, it is an honor and privilege to appear before this court on behalf of the Republic of the Philippines. Together with the head of our delegation, Solicitor General Menardo Guevara, Ambassador Carlos Soreta, and Assistant Solicitor General Bernard Hernandez, the Philippines will address an issue which pertains to the greatest existential threat that we as a humanity face, the climate change crisis. The Philippines, as we speak, is at the tail end of the tropical cyclone season. But the recent 7 destructive typhoons that successively barreled through the country within a month's time were unprecedented in its frequency. In a matter of hours, homes were inundated, livelihoods shattered, years of development work swept away, and precious lives lost. Filipinos are resilient and have coped with calamities, but the typhoon's increasing severity is outstripping adaptive capacities. The reality of extreme weather events, rising sea levels, and other adverse effects of warming temperatures around the world, all of which are beyond natural climate variability, requires all of us to take bold and decisive actions. Mr. President, the Philippines has consistently understood the nexus between the environment, the well-being of states and peoples, and international peace and stability. For one, the Philippines now hosts the Loss and Damage Fund Board, a mechanism operationalized at COP28 as a lifeline for vulnerable peoples and places. In addition, President Ferdinand R. Marcos Jr., in his statement at the high-level general debate of the 77th session of the UN General Assembly, characterized the threats to kalikasan, the Filipino word for the natural environment, as the greatest threat affecting our nations and peoples. It is this understanding that informs our submissions to the Court as we address the request of the General Assembly. In fact, in September 2023, the Philippines urged the International Tribunal for the Law of the Sea to view the warming of our planet and the resulting changes to the natural environment as a threat to humanity and a key risk to international peace and stability. As we convey our gratitude to the Court for convening these oral proceedings, we look to it to provide authoritative guidance to address the worsening global catastrophe and to fulfill our respective obligations in ensuring the well-being of present and future generations in this shared home we call Earth. Mr. President, may I introduce Solicitor General Menardo Guevara, who will speak on the scientific consensus and Philippine situation, to be followed by Permanent Representative to the UN in Geneva, Carlos Soreta, to speak on the UN Charter, Human Rights, and UNCLOS. The Solicitor General will speak again to make further legal arguments and conclude with the Philippine government's submission. I thank you.
I thank His Excellency Eduardo Malaya. I now give the floor to Mr. Menardo Guevara. You have.
Mr. President, Your Honors, the denial of climate change and the impact of anthropogenic emissions is negated by overwhelming scientific consensus. The 2023 synthesis report of the Intergovernmental Panel on Climate Change shows unprecedented global warming of 1.1 degrees Celsius above pre-industrial levels from 2011 to 2020, and has predicted that the warming will more likely reach or surpass 1.5 degrees Celsius between 2021 and 2040. This prediction has come to pass. As of August 2024, the Earth's temperature crossed a critical barrier never experienced in all of human history. The dire consequences of the increasing global temperature, such as severe and extreme weather events, intense heat waves, devastating typhoons with violent storm surges, prolonged droughts, wildfires, catastrophic floods, and their tremendous human toll are life and death realities for many developing states like the Philippines. They are not abstractions. The Philippines, a mid-ocean archipelago, perennially suffers the brunt of devastating tropical cyclones. Historically, East Asia experiences 20 tropical cyclones annually, and about 8 or 9 of them batter the Philippines with increasing frequency and intensity due to the climate change crisis. In December 2012, Super Typhoon Bofa, locally known as Pablo, made landfall in Davao Oriental Province and crossed over to Davao de Oro. These two provinces in southern Philippines have never before experienced super typhoons. Torrential rains generated enormous debris flow from the Mayo River watershed and wiped out an entire village, and in the process, displaced thousands of families, damaged billions of pesos worth of infrastructure and livelihood, and caused the loss of lives of hundreds of Filipinos. Coming on the heels of such devastation was Super Typhoon Haiyan, locally known as Yolanda, which made landfall as a Category 5 storm in the Philippines in November 2013. Its deadly and extremely destructive winds exceeded 315 kilometers per hour, causing storm surges that reach up to 5 meters high. It affected more than 14 million people across 44 provinces, claiming over 8,000 lives and displacing 4 million Filipinos. While undoubtedly the most powerful tropical cyclone to ever make landfall in recent memory, Super Typhoon Haiyan is less likely to hold this record for long. Over the course of 6 weeks, from 1 October to 14 November 2024, the Philippines experienced 7 typhoons. Of this number, 3 reached Super Typhoon category, namely Krathon, Kongray, and Manyi. And 1 reached Tropical Cyclone Warning Signal number 4, namely Yin Xing. 2 of those typhoons alone affected an estimated 9.6 million people, damaged 208,000 homes, displaced 258,000 people, and resulted in 158 deaths. While the typhoon and monsoon seasons bring torrential amounts of rain, the dry months, on the other hand, cause unprecedented levels of extreme heat indices. When we are not being drenched, we are being scorched. In May 2024, the highest recorded heat index in the Philippines reached an alarming 55 degrees Celsius, an extreme danger category which caused successive class suspensions, significantly affecting the quality of education of hundreds of thousands of school children. Data from the Philippine Education Department show that in recent past, an annual average of almost 15 days of on-site learning were lost on account of extreme heat. Not only that, the extreme danger heat index contributed to serious loss in agricultural productivity, affected power supply, and exposed vulnerable sectors of society, such as the elderly, children, pregnant women, and persons with respiratory illnesses, to heat stroke, and in some cases, death. Moreover, in our oceans, higher atmospheric temperature has caused major concerns about rising sea temperatures, ocean acidification, and coral bleaching. These phenomena ultimately affect the ocean biodiversity that is essential to food security and the livelihood of millions of Filipino fisherfolk. Filipino marine biologists have found extensive coral damage in Escoda Shoal, which they attribute to the anomalous warming of the waters in the West Philippine Sea.
My name is Jonathan Anticamara. So my main research is on coral reefs. We go around the Philippines to survey different coral reefs around the country, from the northern part, Apari, all the way to Tawi-Tawi. The most recent surveys and research that I did were in the West Philippine Sea. In April, we went to Pag-asa Island, and then in June, we went to Escoda Shoal to look at what's the status of corals. Both in Pag-asa and in Escoda Shoal, most of the corals, in fact, majority of the corals are either dead or dying, like bleach, and they are now covered in algae. So it's in various stages of degradation. So my conclusion that they're extensively dead, this was mainly due to climate change, such as warming, was drawn mainly from our observation first in Escoda, wherein almost 100% of all the corals are bleached. This kind of bleaching cannot be attributed to localized pressure or disturbances such as pollution. We thought that this phenomenon or this trend is actually attributable to the warming that we experience in the summer. So this must be a climate impact.
It is our humble submission, Mr. President, that this environmental crisis attributed to anthropogenic GHG emissions is surely not experienced in isolation by the Philippines. As we have learned from Vanuatu, the Bahamas, Bangladesh, and South Africa, among others, these unusual and unprecedented climate changes have become a global phenomenon. Mr. President, at this point, I turn over the floor to Ambassador Soreta.
I thank Mr. Guevara. I now give the floor to His Excellency Carlos Soreta. You have the floor.
Mr. President, Your Honors, I will speak on the UN Charter, human rights, and UNCLOS. Mr. President, climate change is a critical environmental issue, but it is also a serious threat to the maintenance of peace and security of mankind, the maintenance of which is a solemn obligation under the UN Charter. Rising sea levels, extreme weather events, and resource scarcity fueled by the climate crisis destabilize regions, exacerbate conflicts, displace peoples, and imperil sovereignty and territorial integrity. The complex crisis creates unprecedented challenges, particularly for marginalized and resource-limited populations. The request pays special attention to small island developing states, and the Philippines finds affinity with their plight. As a nation with thousands of small populated islands facing very complicated maritime disputes, the Charter's provisions on sovereignty and territorial integrity resonate in this context. Climate change-induced sea level rise poses a severe threat to the territorial integrity of low-lying and island nations, analogous to the loss of territory by invasion through the use of force, but without the possibility of exercising the inherent right of self-defense. This can also ignite boundary conflicts. Although climate change was not foreseen when drafted, the Charter is a living document and provides a constitutional basis for interpreting obligations relevant to this crisis, and exemplifies what Judge DeVischer described as the unforeseen and indeed unforeseeable events that the Charter must address. The Charter was created to save the succeeding generations from the scourge of war. It must now save future generations from the ravages of climate change. Mr. President, climate change is at its core also an existential human rights issue. States have clear obligations to protect and respect these rights, including those impacted by climate change. These obligations are rooted in the foundational principles of the UN Charter and elaborated in the Universal Declaration of Human Rights, a crucial interpretative framework affirming the inherent right to dignity and well-being, all seriously threatened by climate change. The International Covenants on Civil and Political Rights and Economic, Social, and Cultural Rights enshrine these obligations. General Assembly Resolution 7630 recognizes the right to a clean, healthy, and sustainable environment as essential for the enjoyment of all other human rights. The Human Rights Council has also passed several resolutions on human rights and climate change. The Orhenda and future generations' decisions, as well as recent decisions by the European and Inter-American Courts of Human Rights, provide compelling legal arguments that states bear obligations to prevent foreseeable human rights harms caused by climate change. The Office of the United Nations High Commissioner for Human Rights has outlined specific obligations for human rights harms caused by climate change, including accountability and effective remedy. Mr. President, the United Nations Convention on the Law of the Sea is the fundamental legal framework, the constitution for our seas and our oceans. So fundamental and organic that the International Tribunal for the Law of the Sea applied it and extensively discussed UNCLOS obligations in relation to climate change, even though this phenomenon was not contemplated when UNCLOS was negotiated. The tribunal, citing the 2016 South China Sea Arbitration Award, emphasized that UNCLOS obligations extend to both protection from future damage and preservation. Mr. President, states are bound to address the climate crisis within a legal framework that maintains peace and security, respects sovereignty, and upholds human rights. Law is essential to ensure a future where all can live with dignity, security, and resilience in the face of a dramatically changing climate. With the Court's permission, I would now like to turn to Solicitor General Guevara to continue and conclude our oral presentation. Thank you, Mr. President.
I thank His Excellency Carlos Freta. I give the floor back to Mr. Guevara. You have the floor, sir.
Mr. President, in addressing UNGA request, the Philippines submits that any act or omission attributable to a state which results or has resulted in anthropogenic GHG emissions over time, thereby causing climate change, is a breach of a state's obligation under international law. Such act or omission is an internationally wrongful act, which necessarily gives rise to a corresponding legal consequence pursuant to international law. Contrary to the submission of some states and non-state parties, the Philippines respectfully proffers that the obligations in respect of the environment cannot be confined within the strict limits of specific international agreements. The insidious effects of climate change require that the entire plethora of customary international law, general principles of international law, and various conventions and treaties be correlated and applied simultaneously. On customary international law, the Philippines submits that the obligation not to cause transboundary harm, enunciated in the early cases of Trail Smelter and Corfu Channel, reiterated in this Court's nuclear weapons advisory opinion, the Iron Rhine arbitration, and the pulp mills case, and included in various multilateral treaties involving the protection of the environment, management of hazardous wastes, and prevention of marine pollution, compels all states to ensure that activities within their territory and control must respect the environment of other states or of areas beyond national jurisdiction. Hand in hand with the obligation not to cause transboundary harm is the state's obligation to exercise due diligence. Attendant to this obligation is the adoption of appropriate measures and the exercise of vigilance in their enforcement, as well as the exercise of administrative control applicable to all public and private entities under its jurisdiction. On the general principles of international environmental law, the Philippines submits that the principles of sustainable development and intergenerational equity are twin principles that are most fundamental when looking into the actions of states and non-state actors as they relate to anthropogenic GHG emissions. While the Philippines concedes that economic development is necessary to further the growth of countries and peoples, it posits that actions relative thereto must operate within a paradigm of non-compromise. We should not compromise the long-term sustainability of resources. We should not compromise the ability of future generations to meet their own needs. On treaties, conventions, and other international agreements, the Philippines respectfully puts forward that the entire gamut of international environmental treaties and documents, as well as that relating to international human rights law, are relevant in the present proceedings. At the core of the actions of states and non-state actors is the most basic of all principles, that the fundamental rights of all races and nationalities, present and future generations alike, must, with no exception, be respected. Mr. President, within the context of customary international law, general principles of international law, and various conventions and treaties, the Philippines maintains that when a state, by itself or through its state actors or other entities whose actions or omissions may be attributable to the state, commits acts or omissions that do not faithfully conform to its international obligations, the same constitutes a breach of a state obligation, and under international law is an internationally wrongful act. The commission of such internationally wrongful act triggers state responsibility with its necessary consequences and carries with it the obligation of the responsible state to cease the wrongful conduct and make full reparation therefor. Accordingly, states affected by internationally wrongful acts of other states in respect of climate change may demand the enforcement of remedial actions, including cessation and/or reparation following the injury caused by such internationally wrongful acts. In the Philippine context, these remedial measures are set out in our Rules of Procedure for Environmental Cases, or RPEC. The rules govern cases involving the enforcement of environmental and other related laws, rules, and regulations, including enforcement of remedies and redress for violation of said environmental laws. The RPEC provides for the remedy of a writ of kalikasan, or writ of nature, a unique and innovative legal remedy espoused by the Philippines and which appears to be the very first of its kind in the entire world. The writ of kalikasan is an extraordinary remedy covering environmental damage of such magnitude that will prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. It is designed for a narrow but special purpose: to accord stronger protection for environmental rights, aiming, among others, to provide a speedy and effective resolution of a case involving the violation of one's constitutional right to a healthful and balanced ecology that transcends political and territorial boundaries, and to address the potentially exponential nature of large-scale ecological threats. Upon the grant of the writ of kalikasan, the reliefs of permanent cessation and desistance, rehabilitation or restoration, strict compliance, periodic reports, and such other reliefs which relate to the right of the people to a balanced and healthful ecology may be granted. Indeed, while the sui generis remedy of our writ of kalikasan is consideredly still of municipal application, such remedial innovation is of value in the present discourse, where climate change is of such magnitude that it imperils present and future generations. Thus, the Philippines respectfully submits the proposition that a similar remedial measure be considered and adopted in the international setting to afford seriously affected states and their peoples with immediate recourse and relief from environmental damage arising from breaches of state obligations under international law. To conclude, Mr. President, Your Honors, the Philippines has no inch of doubt that the entire gamut of international law informs the obligation of states for their anthropogenic GHG emissions in a manner that is far more encompassing than what has already been achieved by the international community under the climate change regime. Now, more than ever, the authoritative guidance of this court is being sought to express in no uncertain terms that the contributory conduct of states in relation to climate change is bound by established conventions, customary law, and general principles. We hope and trust that the court will do so. On behalf of the Republic of the Philippines, we thank the Honorable Court for your time and consideration.
I thank the representative of the Philippines for their presentation. This concludes this morning's sitting. The oral proceedings will resume this afternoon at 3 p.m. in order for Canada, Chile, China, Colombia, the Commonwealth of Dominica, and the Republic of Korea to be heard on the questions submitted to the court. The sitting is closed.